can I call the doctor whom you sued during opening arguments a liar if in fact it's true? If in fact I was able to show that he contradicted himself? Would you like to learn the answer? Come join me for a moment for a walk on the beach as I share with you the exact answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, so now you sued your doctor claiming that he was careless, causing you significant harm and injury. And the doctor turns around and says, hey, why are you suing me? I did nothing wrong. And he disputes every single claim that you have raised. Okay? So now what does that mean? It means that at some point 2 or 3 years down the road, your case will likely go to trial. Okay, so now we get all the way to trial, and what happens? What happens now is that we begin opening arguments. And now you know during the course of discovery, during the course of depositions, taking pretrial testimony, asking the doctor questions before we ever get to trial, you know that I have exposed the doctor for being a liar, for contradicting himself multiple times. Now, I shared that information with you. I gave you his transcript of the questions that I asked and the answers that he gave that took place in his lawyer's office. So we know that. The defense lawyer knows that he contradicted himself. So now, as a strategy during opening arguments, can I actually tell the jury that this doctor is a liar and is not to be believed? The answer is I could. But the jury doesn't know enough yet to truly understand what we know yet. It may not be a great idea to tell the jury, listen, this doctor is a liar. This doctor contradicted himself. You know why? Because they don't know what we know yet. They have not lived with this case for the past 2 or 3 years. They have not seen the testimony. They have not heard the testimony. They don't know what the issues are in the case yet. So what's a better strategy? A better strategy would be to explain to the jury why the doctor might have been inconsistent in his pretrial testimony and how that's going to affect his credibility, rather than coming right out and saying, hey, this doctor that my client sued is a total liar. And you're going to hear testimony explaining exactly how he lied and how he contradicted himself in his own words during his deposition. Now, the jury may not know what a deposition is at that point. And again, unless the jury truly understands, which they won't at that point because they don't have enough information yet since we're just starting the case, it's not a good strategy to turn it around and say, hey, this doctor is a liar. So why do I share this great information with you? I share it with you just to give you a little bit of an insight into what goes on in these medical malpractice cases in New York. You know, I do realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit but have not done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have an awesome day.